Hi everyone. So I promised you all that I'll be coming up with videos related to drafting, and this is one such videos where I'll be showing you how to draft a writ to be filed at the Delhi High Court. Even if you want to file it at any other high courts, or you want to know the general format of drafting a writ, how it is done, this is fine for you. You'll get to know the grounds part, you'll get to know the prayer part, you'll get to know the other essential parts, and through this you'll be able to draft writs for other high courts as well, and even for the Supreme Court of India. Of course there will be many changes, but those will be related to the general parts that are generally available on the court's websites as well. Now this is a writ in the original civil writ jurisdiction, as you can see at the top. We write the name of the court, which is the High Court of Delhi at New Delhi. In my case, you write the jurisdiction, like it is being filed not in appellate jurisdiction, not in any other jurisdiction, but in original civil writ jurisdiction. It is always essential to get to know the jurisdiction in which your case can be filed before making it ready. If you do not know it in the beginning, no problem. You can consult any of your seniors. You can consult any of your associates who has done this particular kind of work, or you can even go to the registry in the respective high court. They will help you out. Now, if you write this jurisdiction wrongly, do not worry. The High Court or the court will mark defects in this, and they will tell you what exact jurisdiction is to be written. So it's not a very big deal. Now, the writ petition number, you cannot fill this number when you are filing or when you are preparing the writ. The reason is when you file it, then you get a filing number, and only after that you can include it here. Now, in the matter of, I have hidden the names etc. from this writ petition to protect the privacy of our clients. Therefore, where I have written Mr. X, you can write the name of your client. Now, the other party, which is the Government of NCT of Delhi in my case, and there are multiple other parties also, that is why I have written ORS, that is others. Now, in your case, if there are no other parties, you can skip this part, no need to write others. If there is simply one party in your case, then you can write ANR, another. Okay. Now, you have to see in your case whether you are a petitioner or you are an appellant, or any other, or you're a plaintiff, because even original plaints are filed in the High Court and original jurisdiction in certain cases. Here you have to see whether you are respondents, whether you are defendants, etc. etc. Okay, so write the correct naming only. Hey everyone, surprised to see me. I hope you were enjoying the video. और आगे जैसे जैसे वीडियो में बढ़ोगे, पूरी रिट पिटिशन कैसे ड्राफ्ट की जाती है टॉप नॉच तरीके से बिल्कुल सीखने वाले हो. बट उससे पहले मेरे पास एक गुड न्यूज़ है. फिजिक्स वाला का बम्पर ऑफर, ऐसी ऑफर, ऐसा सेल जिसके लिए आप सब पूरा साल वेट करते हैं. अप टू 65% ऑफ आपको इसमें क्लैट बैचेस पे मिलता है. कोई भी हो आपकी जान पहचान में जो क्लैट एग्जाम के लिए प्रिपेयर करना चाहता है, उसके लिए ये बेस्ट टाइम है, क्योंकि अभी 65% तक का ऑफ मिल रहा है आपको ऑन अकाउंट ऑफ PW's फिजिक्स वालाज विश्वास दिवस. आपको अपनी स्क्रीन पे सारे प्राइजेस दिख रहे हैं जो कि अनबिलीवेबल है. सो अगर आप ऐसे बैचेस भी लेना चाहते हैं, आप ऐसे ऑप्शंस ढूंढ रहे हैं जहाँ पे आपको क्लैट, आईलेट, ओलेट सबके लिए एक साथ प्रिपेयर करने को मिले, तो भी इन्होंने वो बैच आपके सामने ला के रख दिया है नियरली इन ₹11,999. और अगर आप क्लैट के लिए प्रिपेयर करना चाहते हैं तो आपको 8,000 रुपीज़ से भी कम पे करना पड़ रहा है, नियरली 7,999. ये ऑफर बहुत ही लिमिटेड पीरियड के लिए अवेलेबल है. सो आई वुड रिक्वेस्ट यू ऑल टू चेक द लिंक्स गिवन इन द डिस्क्रिप्शन बॉक्स. इसीलिए मैं आपको वीडियो के बीच में थोड़ा सा परेशान करके ये बात बता भी रही हूँ, ताकि आप लोग उन सब की हेल्प करना अगर चाहते हैं तो कर पाए, जो किसी भी तरह से लॉ स्कूल में एनरोल करना चाहते हैं, एडवोकेट बनना चाहते हैं, जुडिशियल सर्विसेज में आना चाहते हैं. बिकॉज क्लैट या आईलेट या ओलेट्स किसी भी तरह के एंट्रेंस एग्जाम्स फर्स्ट स्टेप हैं लॉ में एंटर करने के. इन बैचेस में आपको लाइव रिकॉर्डेड दोनों तरह के लेक्चर्स मिलते हैं, प्रीवियस ईयर क्वेश्चन पेपर्स मिलते हैं, मॉडल टेस्ट पेपर्स मिलते हैं, एनालिसिस मिलते हैं, टॉप नॉच फैकल्टी मिलती है. So everything that you need to boost your CLAT 2025, 2026, 2027 preparation. You will also get the access to upcoming new batches. अगर कुछ नया आ रहा है, कोई नए टीचर्स आ रहे हैं, वो सब आपको यहाँ पर मिलेगा. साथ में प्रिंटेड मॉड्यूल्स आपको मिलेंगे. ये नहीं है कि आपको सिर्फ ई बुक्स से पढ़ते रहना है. You will get everything printed. इवन जो प्रीवियस ईयर क्वेश्चन की बुक्स होती हैं वो भी आपको मिलेगी. खजाना पैकेज इज अ स्पेसिफिक थिंग इन पीडब्ल्यू. जो अट्रैक्शन होता है स्टूडेंट्स का वो सब भी यहाँ इंक्लूडेड है. So I would say you should not wait for a longer time and you should check the links given in the description box. अगर ये discounted price पे भी और discount चाहिए आपको और effectively इन batches को में enroll करना है आपको, then you need not do anything very complex, but you simply need to use my code ISHA500 while you are purchasing these courses, and I'm sure this is going to help you a lot in your CLAT preparation. All the best. Let's continue the writ drafting. This is the index page that is first filed. If you do not have an index, it will not be accepted. The index will also show you contents of the petition. So any petition first have to contain an urgent application, then a notice of motion, then memo of parties, then synopsis, etc. We'll keep seeing how all of this is done. Then there are multiple annexures in this one after the main writ petition. Okay, writ petition has to be supported by an affidavit. After that, there is a CM here, that is the miscellaneous application, civil miscellaneous application, and then there's wakalatnama, court fee, and proof of service. If you fail to file this proof of service, then your case will be marked for defects. You have to serve it to the other party through email, through even WhatsApp, through mail, if you want it to be successfully filed in the High Court. Okay. Now here you should always write place and date, then whom you are filing it for, whether it's petitioner, respondent, and through your name, etc. The portions that I have hidden here contains the number of the advocate, the contact number, and the email ID of the advocate. It's completely dependent upon you whether you wish to write it or not, but it's always advisable to write it so that if the other counsel wishes to contact you, they may do so through this. Moving on to the urgent application page. See, whenever you are filing an urgent application, this is the same format that you have to follow, no changes. Urgent application just says that there is some urgency in your matter and why you would like the court to hear it urgently, and why this is something important for you. Okay, so you state the reason in let's say very simple one-liner. It has to be there. Even you can use 3-4 lines, but not more than that. Try to conclude this within one page. This is the format. You can use it exactly as it is, no need to change. Same thing with the notice of motion. You do not need to change it. Here you are just telling the other counsel that this is being filed on my client's behalf and it may come up before the court. Let's say you are filing it on the 2nd of November. You will say, I expect that it will be accepted by the court within 2-3 days and it is likely to come up by 4th of November or later. Okay, so you have to tell them to please take notice accordingly. Follow the exact same format, no need to change again. Then the memo of parties as well. You don't need to change this also. The memo of parties remains same. Of course, the name of party differ, then the son of, if you are writing it here, son of, resident of, address, all of this has to be written. Here the hidden part is the name of the petitioner. Now the other parties, you have to write exact names of the other parties, no changes in the names. Okay, now you also have to write the full address of the parties. It is important. If you have the email address, then write it. If you do not have, skip it. Okay. Next comes the synopsis. Okay, synopsis, as you can see here, has to be very short. Okay, you have to tell the court what are you seeking through this petition. Like I've told here, by way of the present writ petition, I am seeking an appropriate writ order or direction holding that impugned inquiry conducted by the IC is not good, it's not valid, it's illegal, it's null and void. So if the court reads synopsis, the court must get to know what this entire case is about, and then you brief a little about the grounds on which you have filed this petition, on which you have filed this case. It has to be super short. If you wish, your synopsis may go for 3 to 4 pages also, but it is my personal suggestion for you to keep it limited. Okay, there are many courts who insist on reading synopsis first, but even before reading the synopsis, they'd like to refer to the list of dates, and this, according to me, is one of the most important documents in your case. Whenever your case goes to the admission stage, the judges say, show me the LOD. And when I was appearing for the first time in the Delhi High Court, I was very much confused. What is this LOD that they're talking about? Then it suddenly struck me, okay, I have to show the list of dates. They wish to know on which date your entire thing started, where your cause of action is arising from. Now, what are you asking? What all happened in the between? It has to be it has to be there in the chronological order. And the courts, this is the favorite part of all the courts, I would say, of all the judges in any of the high courts, even in the Supreme Court, सबको list of dates देखना होता है. And therefore I'd say कि अपने list of dates को आप बहुत अच्छे से लिखें, बहुत अच्छे से डिवाइस करें. And list the last part, the last date in your list of dates should reflect how this entire thing has affected you and what was the last step taken by you which is relevant to the case and why you have filed this petition. So you say in the end, hence the present petition has been filed. I hope it makes sense to you. I'm sorry I am making all these marks. Okay, now comes the main writ petition. Okay, the other parts remain the same more or less for all the cases, of course with minor differences, but this is where your drafting, the real drafting, comes into picture. Now, very important part of this is this title. Okay, you have to keep it short, crisp. You have to reflect in what articles, in what provisions of law your writ is being filed, your case is being filed. What is it? Is it an appeal? Is it a writ petition? Okay, these two are the important things. If you wish to highlight what you are seeking, so you can also say seeking so and so relief. Okay, I mean, don't write so and so, of course, write what relief are you seeking here. Here in my case, the relief was very much, when I was drafting, it was turning into a very long case title, which I felt was not right, and therefore I just wrote writ petition under these articles. But it is very important to write the correct provisions of law under which you're filing. Now this remains same. You are giving it to the Honorable Chief Justice and the companion justices of the Honorable High Court. The registry will decide where it will be filed, of course as per the current roster of the court. Now here starts your actual petition. Most respectfully showeth. This is important. You have to write it. It just means that you are most respectfully showcasing your case, highlighting your case. Okay, now again, right, just like you wrote in the synopsis, right here, what are you seeking? What is your problem here, which you are dealing with? And again, your grounds in brief. It will help you a lot if you write this in the first para. Next para, I always recommend writing particulars of the parties. The reason is court should know who are the parties, which background they are coming from. They'll also get to know if there's any relationship between the parties, which becomes very important for the case. Third is facts. So facts, only relevant facts. You don't need to write all those things which are not only also important for your case. See, the more you write, there are more chances of you getting wrong at some point, or you saying information or writing the information that's not needed and which may land you up in unnecessary trouble. Do not do that. What my advice is, you remember you wrote the list of dates. That is entirely what your facts should constitute. So here simply write those dates in words. Okay, like 17th October 2023 around 10 a.m. this happened. Then the other date, 18th October 2023 this happened. Okay, so just elongate on the list of dates that you've already written, and this way you won't have to write your facts again and again. Also, it will ensure that there is no inconsistency between your list of dates and the facts that you have written. Very simple of doing this is make your client sit in front of you through a video call, or meet your client physically and then ask him what happened on this date, what happened on that date, how did it all start. When they mention dates, just keep noting those dates down. And if they do not remember, you may also say somewhere in October 2023. That's also permissible. But if you have dates, that's always good. Here the facts went on for quite many paragraphs, and this may happen in your case as well. Now in the end of facts para, you say present petition is being filed to ensure that petitioner is treated in accordance with the provisions contained in the POSH Act. This is related to Prevention of Sexual Harassment Act case. That is why I have included this paragraph. See, this is my format, and you may use any other format as well, but I prefer going like this with certain changes for certain cases, but this is something, I mean, if you do this, this is going to really help you. You will have things sorted in your draft, and hence your head will also remain sorted when you're arguing the case, whenever you're presenting your case on the notice stage or any other stage. When you include everything in your paragraphs in your draft, if the court asks, sir, ma'am, have you included this? Mr. Counsel, Miss Counsel, where have you said this in your writ petition? This is their favorite line. You can always take them to the writ petition. If you want to argue at any time, even if you're not prepared, even if you didn't know that this day is going to be argument day, you can simply read out the paragraphs, the grounds, etc. in your writ petition. So keep it inclusive, keep it exhaustive, not inclusive, keep it exhaustive, but try to keep it as crisp as possible. Now, to ensure that it's crisp, it has to it must have many subheadings also. Like I have this para number 4 as grounds, and here I have ground number 1, and then I'm saying para number 4.1. So I always think, before drafting my case, what all grounds am I going to rely upon? Are there any case laws? Are there any legislations which are being not satisfied? If there's a provision that I'm talking about, what are the ingredients of that provision that I need to elaborate upon? So I say that express mandate under Section 6 of the POSH Act, etc. has not been complied with. Then I go on to elaborate upon that. What is this section? Now, what has happened in my case? This is all that goes on in these grounds. I also rely on the case laws that are supporting my case. Some people say do not disclose case laws. Here in your petition, it's not needed. But whenever I feel that it's needed in any of my drafts, then I do it, and I've done it here. There is no hard and fast rule which says that you should have these case laws here, but I like doing it. Then there's ground number 2. The local committee is vested with proper jurisdiction. So I'm saying that this complaint against my client should not have been handled by the authority which handled it. Rather, the local committee should have handled it. Now I go on to reproduce the section which is relevant, and I say how what I am saying is correct. Then again, I rely on decision which supports my ground. Then ground number 3, suspension until the pendency of inquiry is malified. I have to show how it is malified, how it is accompanied with bad intent. I continue to do so in the paragraphs. I also use not only the main legislation but also the rules concerned with the POSH Act. This is what something you should also do. Then ground number 4, there's violation of the POSH Act. There is violation of the POSH rules. There is violation of principles of natural justice, thereby making the proceedings not good, in fact, malified. Again, I continue to utilize the cases which are relevant in my opinion. This, I think, helps the case formulate, an opinion in the beginning only when they're reading your file. There are many judges in the Delhi High Court who take your pleading very seriously, and you should always remember, do not just do your drafts like that ki chalo theek hai, baad mein theek kar lenge, I'll get time to correct it later, or I will do good things when my turn comes up for filing written arguments. No, do it at this stage. It is essential. Your entire case may fall if you do not do your draft well, if you do not give your pleading well. Okay, here I am, I continue to elaborate on the grounds. Then again, there's a table of dates where I'm trying to prove certain thing through picking up only certain important relevant dates, not everything from the list of dates. Thereafter comes at 4.34, that is in 34 paras, all my grounds end. Now comes my ancillary paras, which are there in all the cases eventually, whether it's a writ petition or any other case. Okay, I say I was illegally, hastily terminated. I'm just trying to reiterate the general things. I am suffering through mental agony, depression due to this suspension, etc. that has happened with me. Now I say that termination will cause termination, if not stayed, will cause an irreparable damage to me, because I've also attached a stay application after this. I say that it's imperative that Honorable Court intervenes to put a halt on the illegalities committed without any fear of law by the respondent authorities. I am reiterating all the important things here. That now this important para comes up. Important para related to jurisdiction. Okay, this is essential for any kind of case. Here you say that the Honorable Court has has the jurisdiction required to entertain this matter. Say that no other tribunal etc. is there to handle this matter, and therefore the Delhi High Court has to deal with it so that I can get justice. I have to ensure that the Delhi High Court or the court in which I am filing my case, my writ, only has that jurisdiction and not only not some other court. वैसे तो writ jurisdiction is there with the high courts and the Supreme Court only, but just reiterating so that you know it for other cases. Now this is also an important para. No similar application para. I have not moved any similar application so that the court knows that you are not doing this repeatedly and on purpose. If you have filed similar application, then it will not be dealt with by the court. Okay. Yeah. So no similar application. You also say in the end that I have no other efficacious remedy, alternative efficacious remedy available rather than proceeding under 226 and 227, Article 226 and 227 of the Constitution. You say that it has been made bona fide. That is, there is no illegality, there is no mala fide in filing this writ petition. Now comes the prayer part. This, read it. I would say if you're filing it first time, read it 20-30 times before drafting it. Take advice of your senior, take advice of any of your associates also on this, so that you know that you are doing the prayer correctly. Because many a times when you go to the court, when I said court asks you for a list of dates, courts also ask you for your prayer. They see if this prayer is something which they can grant. You should know what kind of writ you are asking for. What do you wish the court to do? Now this part in the end is also very important, which says any other further order direction as the Honorable Court may deem fit. Some people think what other order direction may be required, but there may be situations where the court feels they will not give you point A, they will not give you point B prayer, they will not give you relief stated in point C, but they wish to do something else. Now, if you have not asked for this something else here in the prayer, it becomes a problem for you then. Of course, the court has powers to go beyond this also, but if this is... But then that only happens in certain restrictive cases, and it's rare. You have to include this para in the end, so that for the sake of justice, equity and good conscience, court may give any other further order or direction as well. In the end, you say that for this act of kindness, your petitioner as in duty bound shall ever pray. This is optional. You may or may not write this. And then later you add your name, etc. After this, you have to attach an affidavit. This is how you draft a writ to be filed in the High Court, in any of the competent High Courts. I hope this made you conversant with the... I hope this all made you conversant with how you actually draft a writ to be filed at the Delhi High Court. If you like this video, let me know. I will have more such videos for you. With this, I can say I'll just meet you again very soon with a new video on a new concept. Bye for now.